and how long it took to recognize women rights as human rights per se. So having that backdrop in mind, we start with today's session with Professor Preeti Mishra ma'am on the aspect of another very important facet of human rights. So without further ado, ma'am, I would hand over the mic to you. And yes, ma'am, we may start.
Okay. So today's topic for discussion is criminal justice administration and human rights. So let us first discuss the objective of this presentation. The objective of this presentation is to provide an insight into the intricacies of human rights issues which are involved in the overall administration of criminal justice system in India. And secondly, to analyze aspects of criminology, penology and victimology with reference to various vulnerable groups of the society. And then to acquaint with the functionaries which are involved in the administration of criminal justice. Then another objective of the presentation is to highlight current issues regarding criminal justice administration and human rights. And lastly, we will be assessing the role of judiciary so far as administration of criminal justice and human rights issues are concerned. So I think and I hope that I am audible to you all, or should I raise my voice?
Ma'am, your voice is perfectly clear.
Okay. So let us start. First of all, now we have this background of human rights, that what is the meaning of human right and what is the nature of human right. So human rights are very, very basic right, very, very inalienable rights which start with the birth of the human being, and these rights are indivisible. And if we are talking about the emergence of human rights, it is not so that with the inception of United Nations organization or with the incorporation of Universal Declaration of Human Rights in 1948, the talk of human rights started, or the discussion or the discourse. It has been always there in a society. If you look upon the ethos and the values of Indian legal system, we will find that human rights has been an intrinsic part of it. But what happened that why now it is so much in vogue and why it is so much talked about issue in present society? Because what happened in earlier stages of civilization, the might was right. Who were stronger in the society, they used to capture the women of others, they used to capture the property of others, and whoever is stronger, they used to hold on the weaker ones. So they started congregating into the groups of the mightier persons who could rule the other sections of the society who were vulnerable or who were weak in as far as their social status was concerned or the economic status was concerned. So people started congregating in the groups, and because of these groups there used to be many clashes, because everybody wants to protect his or own rights or the interest. So always there was a clash between the weaker sections of society and that of the stronger one. So out of this emerged the concept of state, from the fact of, you must have studied the theory of social contract theory. Under the social contract theory, the population in any legal system surrenders some of its rights to the state, and the state in turn takes upon the responsibility to take care of the welfare of its people or to maintain the peace and order in the society. So out of this clashes which used to happen very often, the concept of a state emerged, and first came the concept of the police state, where the primary responsibility of the state was to protect its population and to save them from the external and the internal aggressions. But when this human rights jurisprudence began and the welfare concept came into being, then the state became of the nature of welfare state. Now they have to take care of each and everything of the individual that is forming part of the society. So whether it is the health of the person, or whether it is the economic concern of the society, or it is otherwise looking upon the various interest, or saving the person from the different aggressions which are happening in the society, either from the close quarters or from the internal disturbances or because of some foreign attacks, etc. So now the police concept has given way to welfare concept, where people have surrendered their some of the rights to the state. In turn, that state will take care um, of their life. They will provide the security, safety, will ensure all kinds of freedom, so that the individual can work freely and with peace and can enjoy the fruits of life. So in this series, various laws were enacted, because a state can get hold of its society only through the law. So the laws were enacted for the purpose of regulating the life of the individual. So you must have studied in the jurisprudence the definition of law. So what is the meaning of law? What is the role of law? That we need not discuss in detail, because you all are aware of it. So in order to ensure the peaceable condition in the society and to enjoy its members, to enjoy all kind of freedoms and fruits of their efforts without any hindrance, society started regulate its activities of its members through the codification of laws. And what happens, how these laws are framed, it depends upon the needs of the society or upon the issues which emerge out of certain kinds of conflicts or the clashes in the society. So law keeps on changing. So there are variations in law, there are types of law, there are family law, there is criminal law, there is international law, there is property law. So in order to regulate the various aspects of life, various kinds of laws have been enacted. So one of the law which controls the illegal activities or the deviant activities in the society is the criminal law. So any activity which is prohibited by the society through its law in order to control the deviant behavior comes within the periphery of the criminal law. So if we talk about in crime, so what is crime? So there are various definitions of crime, but the most accepted definition of crime is that of Stephen, who says that an act or omission forbidden by law and revolting to the moral sentiments of the society. So it is not only a deviance from the settled rule of law, but it is also abhorring to the moral sense of the society. It means it gravely affects the life of a person, and not only the life of the person against whom the crime has been committed, but also life of the neighborhood society or the livelihood of the person who are close relative of that particular person against whom the crime has been committed. So it is not an act or omission which is forbidden by law, that we have not to indulge in certain kind of activity, but it also somewhere affects the moral sentiments of the society. So what is the morality? It is nothing but the settled principles of behavior which we follow at a certain given time. And you all know that the principles of morality differ from each country, from one country to another country, because what is the moral standard in Indian society may not be in the Western society. So their moral standard may be different. Now you must be witnessing this Taliban crisis. They are setting a different kinds of moral standard for their society. So it depends on each and every legal system. And then another definition which is given of crime is that by Professor Caney. He says that it is an act, an omission which is a public wrong, and it cannot be, it is not remissible. It can be remissible only by the king alone. So a wrong which can be forgiven by the king only. And similarly, you have the provisions of mercy power given to the president and the governors, because whenever the crime is committed, the culprit moves the wheels of justice and he runs from pillar to post in order to save his life or to absolve himself from the guilt with which he has been imposed upon. And the last resort that can be made is that of the mercy petition. So a crime is that which is prohibited, any act which is prohibited by law. So if we look upon the Indian scenario, we find that there is IPC, Indian Penal Code, where the various acts have been defined as crime. And section 40 of the IPC says that not only those acts which have been defined as crime in this particular act, but by any specific law also. So there are a plethora of specific laws which also gives different kinds of offenses which comes within the definition of crime. And then Blackstone looks upon it as a violation of public law. And this picture of definition of criminal law becomes much more clear when we compare it with the definition of or from the contract and the tort. And you must have studied in your LLB classes that how the crime is different from contract and the tort, because crime is a public wrong, whereas contract and the tort is a civil wrong. And so far as the repercussions are concerned, it is also different. In tort or in contract, two individuals are affected, but in case of crime, several persons of the society are affected, though the crime is committed against one single person. Then in terms of damages also, there is difference whenever the crime happens, there is penalty provisions, the imprisonment may be there, the fine may be there, forfeiture of property can happen. But so far as the tort or the contract are concerned, the damages are given, and sometimes the exemplary damages are also given. So the law tries to put a kind of check up not only upon the activities of the individual, but also upon the activities of the state. Because if the state is powerful, it is going to violate the human rights of its persons. So criminal law not only puts a check upon the persons who are indulging in some kind of crime, but also upon the power of the state. So now, after understanding what is the meaning of crime and how it is different from the contract and the tort, now we can deal that what is a criminology, why a person commits a crime, and why different kinds of penalty provisions are there in our penal laws. Because a murder may be committed by a juvenile, may be committed by an elderly person, may be committed by a pregnant woman, but the sentencing policy may be different for different classes of persons. So the penalty provisions in criminology depends upon the nature of the crime as well as the age and sex of the individual who has committed the crime. So why it is so? Because if we study the criminology as a part of the criminal law, and it is a very important facet of human right also, that and there is basic principle of criminal jurisprudence also, that every person is presumed to be innocent in the eye of law till the guilt is proved beyond reasonable doubt. So unless and until the guilt is proved, but for the purpose of proving that guilt, lots of many factors are to be taken into account, that why a person has committed a crime. So if we look upon the criminological theories, we find that there was a theory of Lombroso which said that the criminals are born criminal, and it is because of certain atavistic tendencies which they inherited from their ancestors, because of which they commit the crime, and so they should be dealt with iron hands, and no leniency should be given to them in terms of their punishment. But when the psychological theories started pouring in, a lot of medical jurisprudence also developed, then it is found that a person is not a born criminal, but it is because of the circumstances in which a person lives. So here comes the theory of Sutherland, that is of differential association. So it depends in which group a person belongs to, whether he belongs to an antisocial behavior group people or to the group of peace-loving people. So it depends to which group he or she belongs. So upon that depends the penological factors. So if one is forced by the circumstances to commit the crime, then the sentencing policy may be different. But if one is intentionally committing the crime, the punishment provisions are different. Or if the child is committing a crime or the juveniles are involved in crime, then there is a different kind of treatment given to them. They cannot be put into jail, they cannot be put behind the bars, rather a kind of rehabilitation process is done for them. So because of the development of the psychology, because of the development of the medical jurisprudence, now it is thought that a person who is committing a crime is a sick person or mentally ill. That's why the theories of punishment, the object of punishment also changed. from retributive theory to the reformative theory of punishment. So that way a lot of changes have come if we study the criminal law, because criminal law involves various aspects, not only the uh, criminal law, which comprises of Indian Penal Code, CRPC and the Evidence Act, but also comprises of the criminology, which tries to study the behavior of the person leading him into the world of crime. So various theories of crime, what are the theories responsible, or what are there were different exponents or the different criminologists who have defined the crime in a different way, as well as they have given the exposition to the fact that because of the various regions people commit the crime. And then this development of the penology has also changed over the years, because in earlier times, if you look at the Muslim rule, you will find that the punishment given were very, very harsh, and very, very barbaric types of punishment were given. People were thrown before the lion, or they were trampled below the feet of elephants. So that kind of barbaric, or by putting to death by stoning, etc., that is still happening in the Taliban. So that kind of penalty provisions were there in olden times. But the thing started changing when the British rule came, and they gave a sort of egalitarian concept, or they brought the egalitarian concept in the criminal law also. Because if you look at the IPC, you will find there is no difference that who is committing a crime. It only matters that what nature of crime has been committed. So whether a person belonging to the higher strata of society commits a crime, or a middle class person or lower class person, so same kind of treatment or punishment is to be given, depending of course depending upon the nature and the gravity of the offense. So if we look upon the criminal law, we not only study the IPC criminology, IPC evidence and the CRPC, but also the criminology as well as the penology. And a very important area that has emerged is that of victimology also, because earlier the criminal law used to revolve around the criminals only, that why a person becomes a criminal, why he commits the crime, and if he or she has committed a crime, what kind of treatment should be given, how he or she should be rehabilitated in the society. But now the balance has changed. Now the studies are also being made from the perspective of the victims, that how the victims' interests are adversely affected whenever the crime is committed, and how the victims can be compensated, how they can be rehabilitated after the crime has been committed against the victim. So victimology has also grown too much these days, and a lot of emphasis is there on the study of victimology also from the perspective of the human rights. So if we try to understand who are the authorities, or what are the components of criminal justice system, we find that it comprises of four things. Number one, legislature. Number two, executive. Number three, judiciary. And number four, corrective administration. So all these four components are very, very important, and they deal with different aspects of crime control in the society. So far as lawgivers are there, they set the parameters of behavior in the society and define a crime according to the perception and needs of the society. And they also prescribe the procedure for the verification of the deviance or the antisocial behavior. So the lawgivers not only deal with what will be the procedure for the investigation, or what will be the procedure for determining the guilt of the accused, then what will be the nature and quantum of punishment, and what will be the procedure for the correction. So all this comes within the domain of the lawmakers. And here the basic law that is there, in accordance which all the laws are framed, is our basic law, that is the Constitution. So all the laws which are being enacted, whether it is civil law or it is the criminal law, all the laws have to satisfy the constitutional principles. Means basic principles of human rights must be there, either we are investigating the crime, or when we are laying down the sentencing procedure, or when we are dealing with the criminals in the prison. So all aspects of criminal law must be looked upon from the human right perspective, and that too as per the constitutional standards given. And secondly comes the role of law enforcers, who are responsible for making these laws implementable. So, state through its police power, through its police organization, tries to control the society and enforce the laws. So, the primary law enforcement machinery, that is police, is charged with various kinds of functions. It is responsible for the maintenance of peace in the society and to prevent and detect the occurrence of a crime, to collect and present the material evidence in proof of violation of any act before the judicial authorities, and the police authorities also assist in the administration of justice. So here one thing must be noted, that police do not have any power to pronounce the guilt or punish a wrongdoer. They can only investigate into the things, they can collect the evidences that they will produce before the court of law, which is ultimately responsible for the for the purpose of deciding the guilt of the accused or the person who has committed the crime. So primary function, or that is the third component of criminal law, which is responsible for the administration of criminal justice, is judiciary. The judiciary is the foremost authority which goes for the adjudication of the guilt. It determines that what law has been broken, in which way the law has been broken, and what will be the quantum of punishment. And all kinds of sentencing policies to be decided by the judiciary only. And then comes the role of correctional administration. The correctional administration carries out the punishments which are provided in the law in case of any act and omission which is to be awarded by the judiciary. So what is the aim of this correctional administration or the correctional authorities? Their responsibility is to reform the citizens or the persons who have committed the crime and to recycle them back into the society. And you all know that with the human rights jurisprudence and with the theories of criminology and penology, now the main objective of punishment is deviated from retribution to reformation. So most of the correctional administration which are there in the name of prison, reformatories, observation homes, or the restitution centers, they are all responsible for mending the ways of the person who has committed the crime and brought him back to the society as a normal human being. So these are the four components which are responsible for the administration of criminal justice. The state through its police power, the lawmakers, the judiciary, and the correctional agencies. And now what safeguards is to be taken if the human rights are to be ensured so far as criminal justice administration is concerned. So one thing which is very, very important is that is of due process. So due process is to be followed, whether it is investigation, whether it is trial, or whether it is fixing the guilt of the accused, or whether awarding the punishment. Everywhere the due process need to be followed. So the basic principle of criminal jurisprudence that we already discussed is the presumption of innocence and the burden of proof. A person is deemed to be innocent until and unless his or her guilt is proved beyond reasonable doubt. And then this burden of proof, the burden of proof will always lie upon the prosecution, barring certain exceptional situation where the crime is committed against women or some vulnerable section of society. So, and this burden of proof is also to be discharged beyond the reasonable doubt in order to prove the guilt of the accused. So when all these things are being taken into account, or when the process is there for the adjudication of the guilt of the accused, then certain safeguards need to be followed in the administration of criminal justice, because the human rights are mainly concerned with the dignity of the individual. And what happens if a person commits a crime? It does not mean that he is no longer a human being. Even if he or she has committed a crime, the human rights are to be ensured. So criminal justice system provides certain kinds of safeguards in order to ensure that the rights of the individuals are protected and the human rights are not violated, even if they have committed a crime. So all the laws which are there, all the criminal laws, whether in the IPC or in the other specific laws, they are to be tested on the touchstone of the Constitution, and the enforcement has to be within the four corners of law. You must have studied in the interpretation that so far as criminal law is concerned, strict interpretation is to be done. So if a person commits a crime, then his act must satisfy all the requirements which are required for the committing of that particular crime. It means his act must fulfill all the essential ingredients of that particular crime. So the enforcement has to be within the four corners of the law, means the strict interpretation of the penal law. No one should be irresponsible held to be a criminal. And then the adjudication of guilt is to be done by the judiciary alone. And all the wings of the what happened? Am I audible?
Yes, ma'am. You are very audible.
Yes, ma'am. Yes, ma'am.
Okay, some voices were coming. That's it. So I was saying that a strict interpretation of criminal law is required, and then other natural justice principle also need to be followed. The rules like rule against bias, the order alteram partem, and the order should be a reasoned order. So whenever judiciary is passing an order for the purpose of sentencing, it must be a reasonable order with all the explanation of the circumstances that why a person is being charged with a particular kind of offense and why with a particular kind of punishment. So the order must follow with particular explanations. So natural justice principle involved, as in our constitution also, the rule against bias that is ensured by Article 14, order alteram partem, that other party should also have the right of hearing. No one should be put behind the bar without giving him the reasonable opportunity of hearing. Then whatever order is being passed, it should be based upon some basis. So in order to maintain the order and peace in the society and to prevent and detect the control of the crime, the state provides its law enforcement authority, particularly the police, with a very wide ranging powers. So here the need comes for putting a check upon the police power, so that it may not be used arbitrarily and it may not impinge upon the dignity and the liberty of the individual. So in order to preserve the rights of the human beings, it becomes very necessary and important to have some kind of built-in safeguards in the criminal justice administration. So the concern of the human rights of individual in the criminal justice administration is very important. So now if we try to understand the fact that from where all the laws which are there will define the crime, or all the criminal law which are there, even though they were enacted before the coming into force of our constitution, from where they get their legitimacy. So a law which was defined in 1860 in the name of IPC, different kinds of offenses are there which make a person deviant if it deviates from the settled norms of society. So from where and if you look at our older CRPC, you find it was of 1898 and Evidence Act is still of 1872, and very few amendments have been made in these criminal laws. So from where these laws get the legitimacy? So here comes the Article 372. Article 372 gives legitimacy to all the pre-constitutional laws as well as to post-constitutional laws, and it very much requires that all the laws must be tested on the touchstone of the fundamental rights. So no law can be framed which divides apart from which takes away or snatches the freedom or the liberty of a particular individual. So it does not matter whether a particular person has committed a crime, even then his right to life, liberty and dignity cannot be compromised or cannot be taken away. So though the constitution provides legitimacy to all the pre-constitutional laws as well as to the post-constitutional law. But the fact is also that a person who is committing crime is also ensured of his human rights, and there also while determining his guilt, the principles of natural justice are to be followed. So from where we can borrow that constitutional guarantees have been given, or the constitutional foundations have been given to the criminal law. So for that, various articles are there which we can discuss. The article 14 is very much there, which ensures the right to equality. So as I told you that it does not matter that who is committing the crime, whether the person is rich or the poor, or educated or uneducated, all are to be treated equally so far as the criminal justice administration is concerned. Then we have very important article, that is article 20, which has got 3 clauses: ex post facto law, double jeopardy, and rule against self-incrimination. So the basic principle of jurisprudence is also that nulla pona sine lege and nullum crimen sine lege, means there cannot be any crime without a law, and there can be no punishment without a law. So an act will come within the 4 corners of crime only when it has been defined at a particular point of time. And even the penalty provisions can also be there only for the act which has been defined as a crime. So there can be no punishment without a crime, and there can be no crime without a law. That is ex post facto law, that no retrospective effect can be given to the criminal law. And then double jeopardy, no person can be punished twice for the same offense. And third is the rule against self-incrimination, that is no one can be forced for eliciting the evidences. No undue pressure can be used. No a person like that this police personnel, they commit the 3rd degree torture in order to elicit the in order to force the witnesses and the culprits to bring out the thing that one has committed the crime. Just they force the person. So that is not as per the constitutional principles. It is against the rule of self-incrimination, means no one can be forced. So these are the constitutional guarantees of the criminal law. Then very important article is article 21, which secures the right to life and personal liberty with dignity. And you all know that after the Maneka Gandhi, it also involves a due process clause, that whatever laws are there, they must be just, fair and reasonable. Barely laying down the procedure for taking away the life of a person is not sufficient. It must follow the principle of natural justice, the due process, that is must be just, fair and reasonable. Then various safeguards are given under article 22, which provides the steps which can be taken, that the unlawful arrest cannot be made, and if a person had been arrested, the ground of arrest has to be explained to him. Then he should be given the opportunity to contact the lawyer, and the bail provisions are also there, that a person cannot be kept in the police custody beyond 24 hours, including the time of the travel. So that kind of safeguards are incorporated. The procedural safeguards are there under the article 22 of the Constitution. And then we have this legal aid provision also under article 39 capital A, that a person must get a legal aid, that is he must be given the chance to hire the lawyer. And if one is an indigent person, poor, cannot afford the lawyer, then the state should provide the legal aid, because every person, because of this basic principle of criminal jurisprudence only, that one is presumed to be innocent and the right of hearing must be given. And then we have very important article for the enforcement of the fundamental rights, that is article 32 and 2 to 6 of the Constitution, for the issuance of different writs. So all these Constitution provides a basis or constitutional foundations of the criminal jurisprudence. Let me skip some of the slides. So If we up till now we looked upon the substantive law, that how the substantive law relating to criminal law have the constitutional sanctity. And then if we talk about the procedure which is there for the purpose of investigation and for the purpose of proving the guilt of the accused, so we can also locate certain constitutional foundation in procedure code also. So if we look upon the CRPC that of 1898, that was changed in 1973 on the recommendations of the Law Commission report, which was the 41st Law Commission report, which suggested a lot of changes. And in 1973, on the basis of this Law Commission report, new CRPC was framed. And this new CRPC incorporated the various principles of human rights jurisprudence. It ensured that due process consideration, it ensured the speedy disposal of the cases, as well as it provided fair deal to the poorer sections in society, because CRPC also involves a number of provisions which deal with human rights jurisprudence so far as this criminal law is concerned. So for the purpose of a speedy disposal of the cases, there is clear demarcation of different stages of the crime, and on the different stages of crime, different functionaries are involved, and all have the responsibility to expedite the process so that the justice can be done, because we all know that justice delayed is justice denied. Then various safeguards are provided in the CRPC at the pre-trial stage. Then the right of pre-sentence hearing is also there, and the CRPC also focuses upon the reformative sentencing. Then there is provision for the indigent accused also, and recently after the amendment in 2005 and 2009, now it incorporates the principles of victimology also. Now we have the full chapter devoted to the victim compensation scheme. So if we look upon the speedy criminal proceedings under the CRPC, we find that section 57 of it prohibits the police custody beyond 24 hours without the authorization from the magistrate. And if beyond 24 hours the criminals are to be kept in the police custody, then the application has to be moved under section 167 of the CRPC to the magistrate. And only it is the magistrate who can grant two kinds of remand, that is police custody remand or the judicial custody remand. And the police remand can only be given at the initial stage for a maximum period of 15 days. But this judicial remand may be for a longer period, but it has to be extended only 15 days at a time. So after 15 days only it can be extended for another 15 days, and then a remandee may remain under the trial only up to a period of 90 days in cases of offences which are punishable with more than 10 years. But in all other cases, the maximum remand period can be of 60 days only. So in order to check the power of the police, that they do not deal with the criminals with the high-handedness or with iron hand, these kinds of security provisions have been brought within the framework of the CRPC also. And if you look upon the pre-trial stage right of the accused, so there is check upon the power of the arrest regarding the search and seizure and to interrogate the person. And most significant encroachment on is effected by the exercise of the power of the arrest, because police have got extraordinary power sometimes, and without warrant also they can apprehend the person. So not only through the provisions which are there in the CRPC which have been brought by the amendment, but also through the judiciary, a number of safeguards have been given so that arbitrary arrest cannot be made by the police. So sections 49 to section 60 enumerate the rights of the accused regarding the illegal arrest or the arbitrary arrest. So these types of safety provisions are there in the CRPC. Then other important sections of CRPC are section 50, which talks about right to be informed of the ground of arrest. Then section 50 capital A, which says that it is the obligation of the person who is arresting a person to inform a nominated person about the fact and place where the arrestee is being kept. And then the medical examination is also to be done by a registered medical practitioner after the arrest, as per the provision of section 53 of the CRPC. Then section 41 capital A says that all the arrests are to be rationalized by providing distinct procedure for arrest in respect of offences which are punishable with imprisonment which is less than 7 years. So different kinds of procedures are to be followed depending upon the nature of the crime which has been committed. And then certain formalities are required to be completed before the arrest as per section 41 capital B of the CRPC. And it is a duty of the district level control room to display the details of all the arrested persons on a board which is fixed there in the at the conspicuous place as per the section 41 capital A. And then 41D provides that it is the right of arrestee to meet an advocate during the interrogation. And section 59 is also important, which says that arrestee is not to be released without the legal proceedings. So these are the provisions in the CRPC which follow the constitutional principles of natural justice. And now right of pre-sentence hearing. It is also very, very important right of the person who has committed the crime. And there is an obligation upon the judiciary also to avoid the reformative sentencing. Because of the change in the psychology of the authorities who are there, and because of all the development which has taken place in the field of criminology and penology. So before passing the order on sentence, the court is obliged to consider the imposition of reformative sentence as provided in certain specific laws. And one important law is the Probation of Offenders Act in 1958 and the Juvenile Justice Laws, section 360 and 361 of the this CRPC. So it depends that who has committed a crime. If a juvenile has committed a crime, or a crime has committed by a person who is first offender, there are different kind of sentencing policies to be taken into account. And if the crime is being committed by a person who is a recidivist, who is a habitual offender, so a different kind of sentencing policy is to be taken. But this sentencing policy only depends upon the eloquence of the judiciary, because there is no settled principle regarding the sentencing policy. So we have seen that not only the substantive criminal law but also the procedural criminal law need to follow the constitutional principles of natural justice. And now we will talk about something about the victimology also, because it is also very, very important part of administration of criminal justice. So this United Nations in 1985 has adopted a very, very important declaration, that is Declaration on Basic Principles of Justice for Victims of Crime and Abuse of Power. And this declaration is very, very important recognition of the need to set the norms and minimum standards in international and legal framework at the national level for protecting the rights of the victims of crime. So this United Nations Declaration on Basic Principles of Justice for Victims of Crime and Abuse of Power has four major components of the right of the victims of the crime. Number one, to access to justice and fair treatment. Secondly, about restitution. Thirdly, compensation. And fourth is rehabilitation. So from all these four aspects, the victimology is to be dealt with at the international level. So previously the balance of criminal justice was in favor of the criminal. All the discourse, all the discussions used to be revolved around the criminals only, but now the victims are an important part of the criminal justice administration, and their interest is also to be protected. So even if we look upon historically upon the victimology, we find that even in olden times also the victims' rights were secured, and we find some references in the Manu Smriti also about the compensation which was to be provided to the victims of criminal law. And you must all have studied the English criminal law, that is the Anglo-Saxon system of criminal law, and there also the victim was not completely neglected, because we find the references to victimology not only in Manuspati, not only in Anglo-Saxon law, but also in the code of Hammurabi. So it is quite common that in the early civilization also the emphasis was there to protect the rights of the victim also, and which has now come to be known as the restitution of the victims of crime. But now the more discussions and discourses are taking place upon the victimology, and we find that the 2018 amendment of IPC, where especially the cases relating to sexual crimes are concerned, when the penalty is being imposed upon the criminal for committing the crime, that penalty is, or that penalty fine is to be given to the victim for the purpose of rehabilitation and for the purpose of the medical expenses also. So the victimology has now been a part of the substantive law also. So not only in the procedure the victimology has to be followed, but even substantially also. You all know that in CRPC also the whole compensation scheme is given. So now the victimology is finding its due place not only in procedural law but also in substantive law. And all this has happened, and the credit goes only to the Malimat Committee report of 2003, which was there for suggesting the reforms in the administration of criminal justice. On the basis of this Malimat Committee report of 2003, various amendments were made in 2005 and 2009 in the CRPC, and many new provisions have been incorporating the principles of human rights. So for the first time, and though the CRPC was there from 1973, but the definition of victim was not there. So very first time the victim has been defined by these amendments only. So section 2WA now talks about the definition of the victim, and then victims have the special right to appeal under the CRPC under section 372, and victim is also the part of the plea bargaining now under section 265 capital C of the CRPC. So if you look upon the definition of the victim, which has been incorporated through the Criminal Law Amendment Act 2009, it says that the victim is a person who has suffered any loss or injury caused by the reason of the act or omission for which the accused person has been charged, and the expression victim includes his or her guardian or the legal heir also. It means the victim is not only the person against whom the crime is committed or crime has been committed, but also his or her guardian, that is the guardian of the victim, as well as the legal heirs. So suppose the crime has been committed against a victim and he is no more, murder has happened, or the rape with murder has happened. So victim is not there, but the victimology will work in favor of the guardian or the legal heirs. So not only under the CRPC, not only under the IPC, not only under the Constitution, the victimology principle have been ensured, but there are special laws also which talks about the victimology in the name of the compensation. Compensation which is given to the victim is nothing but an aspect of the victimology, and it is not so that it was not there earlier. In 1973 CRPC also compensation provision was there, but it was a part of the fine which was imposed upon the accused. No separate provision was there, but after the amendment of 2009, a separate chapter has been included. Then under specific laws of SC/ST Act, Domestic Violence Act, Probation of Offender Act also, the compensatory provisions have been included. So the compensatory jurisprudence which has developed and which is still developing, it is a part of the victimology, the growth of the victimology, which is very, very important aspect of the administration of criminal justice. So besides this criminal laws and constitutional provisions, there are certain administrative measures also which work in the field of administration of justice for the purpose of ensuring the human rights. So during the last decade, the government of India has framed various kinds of schemes in order to strengthen the victim justice. And some of the schemes which are important and which can be noted are the scheme for the relief and rehabilitation of the victims of rape, and the compensation is to be given to the victims of violence who have faced violence by the left-wing extremists. Then there is central scheme of assistance to victims of terrorist and communal violence. There are rehabilitation packages to provide relief to the victims of 1984 riots. We have Ujjwala scheme for the prevention of trafficking and rescue, rehabilitation and reintegration of victims of trafficking for commercial and sexual exploitation. And recently, the government of India, the Ministry of Home Affairs, has issued various advisories for the various states and the union territories to not only to prevent the crime but also to prevent the victimization of the vulnerable sections of the society, such as women, children, and marginalized section of the society. And in this regard, the UP government's Mission Shakti program has been very, very popular. So government are also taking initiative to ensure human rights to the victims. So it is a part of the responsibility of the state to protect its citizens and to safeguard their interests. Then we have various kinds of authorities also, institutions also, which are ensuring the establishment of the principle of human right so far as administration of criminal justice is concerned. You are well aware of the law, that is the Human Rights Act of 1993, Protection of Human Rights Act 1993, which talks about the establishment of National Human Rights Commission and the State Human Rights Commission at the state level. Then the section 30 of this Protection of Human Rights Act 1933, it makes a provision for the human rights courts for the purpose of trying the offences which arise out of the violation of the human rights. So these NHRCs and SHRCs are also working to a great extent for enforcing the human rights so far as administration of criminal justice is concerned. And the other specific institution, as we lastly talked about with reference to women, there is National Commission of Women, the State Commission of Women, Children Commissions are also there, SC/ST Commission is there, other backward class commission is also there. So various kinds of institutions are also there which all help in the administration of criminal justice and for the purpose of ensuring the human rights. Now let us come to the very, very important aspect of our lecture, that is the role of judiciary, and what important role it has played so far as administration of criminal justice is concerned. So as per the constitutional principles, our judiciary is working, and if you look upon the Article 142, so in the name of doing justice, any kind of order or decree can be passed by the Supreme Court. So with furtherance of that particular article, lots of human rights jurisprudence is taking place in the field of administration of criminal justice. So mainly if we analyze the role of judiciary, we find that it has worked a lot so far as the criminal jurisprudence is concerned. So there are cases deciding the constitutionality of the death penalty, criminalization of attempted suicide, decriminalization of consenting adult homosexuality, fair trial requirements, compliance with the amended law of arrest, equality in the equality principle brought by judiciary in the criminal justice administration, as well as judiciary has also delivered many proactive judgments so far as custodial justice is concerned. So after the Maneka Gandhi case, a lot of changes have taken place so far as administration of criminal justice is concerned, because of the due process clause which has been inserted under Article 21. So if I quote Supreme Court as said in the Maneka Gandhi's case about Article 21, it says that Article 21 forbids deprivation of personal liberty except in accordance with the procedure established by law, and curtailment of personal liberty to such an extent as to be a negation of it would constitute deprivation. Bar fetters make a serious inroad on the limited personal personality which a person is left with, and therefore before such erosion can be justified it must have the authority of law. I unquote. So after this case only, a lot of human rights jurisprudence has taken place in the field of criminal law. So there is a long list of cases, and you must all have studied these cases also, like Hussaina Khatur versus Home Secretary of State Bihar, M.H. Haskote case, then Dayal Singh case, Sunil Batra case, you all aware of, Charles Sobraj case, Prem Shankar Shukla versus Delhi administration, Bathiswaran versus State of Tamil Nadu, Sheila versus State of Maharashtra, Rudul Shah case, Hussain Ara case. All these cases are very, very landmark cases so far as administration of criminal justice is concerned. And recently this case of D.K. Basu versus State of West Bengal of 1977, it dealt with the principle of ubi jus ibi remedium. And in the case of Francis Corelli versus administration, Union Territory of Delhi, and in Nilbati Behra case, even Supreme Court held it to the extent that constitutional and juristic foundations of the liability of the state is formally fixed, and now the state cannot claim the defense of sovereign immunity. So even the claim of sovereign immunity which arise out of the state discharging its sovereign functions is no longer a defense if there are acts of violation of the constitutionally guaranteed foundational human rights. So if the states are themselves indulging in the cases of the violation of human rights, they cannot take defense of the sovereign immunity. Even the state authorities can be held responsible. And now you all know that in the cases of terrorism, etc., the state has been made responsible for paying the compensation. Or in case of communal violence cases, where a group of persons are affected, even they are made responsible for compensating to the victims. So in the name of doing justice, the state itself cannot negate the fundamental human rights of the individuals involved. Then we have very important judicial landmark case of Srimati Selvi versus State of Karnataka, where the various guidelines were laid down for the lie detector test of an accused, because now it has become a sort of fashion to put the accused upon the lie detector test. But court has remarked that it is also a kind of human rights violation, because here the consent is not taken, or the person who is giving the statement is not in his senses because of the administration of certain kind of drug which is given in order to elicit the evidence from the person in order to do the lie detector test. This is nothing but the human rights violation, because here the consent is not free. So this is a very, very landmark case of 2010. And then for the delay in execution of the sentence also, there are very, very landmark cases that if there is going to be a delay which is inexplainable, for which no justified reason can be given, there the penalty provisions are to be commuted. It means if the death penalty is there, it has to be commuted to the life imprisonment, or if life imprisonment is there, then it's to be commuted to the some other simpler form of punishment. So because of the delay, the culprit need not suffer even if he or she has committed a crime. So if the fault is on the part of the administration, fault is on the part of the judiciary, so for that the compensation should be made in terms of the commutation of the sentencing. So we have a number of cases where the death penalty has been limited to life imprisonment because of this undue delay by the judiciary. So in Shatrughan Chauhan case of 2014, which was a 5-judge bench judgment, here the death sentence of 15 persons were commuted into the life imprisonment. Then even in Muhammad Arif case of 2014, it was said that the oral hearings can also be held even if the review petitions are there so far as the sentences are concerned. So these cases, the Shatrughan Chauhan case, Muhammad Arif case, these are the very, very landmark cases. And another case which brought out the sordid state of affairs in the administration of criminal justice as Santosh Kumar Bariyar versus State of Maharashtra. And this is a very, very landmark case on the death penalty because it laid down two important principles. Number one, the power of the session court to grant the pardon as per the provision of section 307 of the CRPC, and another interpretation of the rarest of rare doctrine so far as awarding the death sentence is concerned. So in this particular case, Santosh Kumar Bariyar versus State of Maharashtra of 2009. In this case, Supreme Court examined the power of the session judge to grant the pardon, but it also concluded that, I quote, if it is to be held that in each and every case, pardon can only be granted at the initial stage, the power conferred to the session judge grant under section 307 of the CRPC for all intent purpose shall become useless. Hence, the court reaffirmed the wide discretion of the session judge to grant pardon under section 307 of the CRPC. And so far as this interpretation of rarest of rare doctrine is concerned, now the court have to make a balance between the aggravating fact and the mitigating fact of the case, that which overweigh the other. If aggravating factors leading to the gravity of crime are more, then the death penalty can be given. But if the mitigating factors are there which are lessening the gravity of the crime, there the death penalty is not to be given. So now a balance is to be done between the mitigating factor as well as the aggravating factors of the crime. So it will depend the nature of the crime upon the gravity of the crime, whether the death penalty is to be given or it has to be commuted to the life imprisonment. And you have plethora of cases starting from Bachan Singh to the present cases. So in this way, if we analyze the role of Supreme Court in dealing with the human rights issues, there are n number of cases which can be quoted, but we can not deal with all these because of the paucity of time. So now look upon certain more recent cases which have been taken upon by the judiciary ensuring the human rights during this COVID period. So if we look upon this period of COVID, we found that lots of human rights violations took place because of this crisis, because the people were, because the culprits or the inmates in the prison were languishing in the jail, and they had the fear that they could contact this deadly virus. So Supreme Court also came forward and issued a number of guidelines in order to make the criminal jurisprudence much more friendly. So in the case of Patan Jamal versus State of Maharashtra 2021 case, the Supreme Court held that the testimony of the disabled witness cannot be considered weak or inferior just because they comprehend with the people in a different way. So their testimony is also to be recorded. And then the Supreme Court issued many guidelines for the release of prisoners on the interim bail, because there was the fear that because of the overburdening of the prison system, the inmates may catch the virus. So not only the Supreme Court but the High Courts also came forward and issued a n number of guidelines to provide solace to the inmates who were there in jails. And to the extent that the court said that the provision of transport is to be made by the uh, prison authorities only, that how the prisoners can be commuted from prison to their safe places. And then there were certain persons who didn't want to go to their homes, because we all know that many of the criminals come from very very low strata of society, so they do not have the places where they can have a life of dignity. So many of the inmates didn't want to leave the places of prison. There also Supreme Court came to their rescue and said that even if they want to remain in the prison, they can remain in the prison, and all the security provisions, all the medical uh, provisions are to be ensured by the prison authorities also. So during this COVID time also, a lot of judicial activism has taken place in order to ensure human right uh, justice to the person who are indicted with any kind of crime. And another very very important aspect is that of the legal aid, that I just made a cursory I didn't dealt with it in detail, though it is a very very important aspect so far as human rights jurisprudence and criminal law is concerned. So legal aid, so we all know that Article 39A is there, then a specific law, Legal Services Authorities Act is there. Then there are various Supreme Court cases also which have ensured this legal aid to the person who cannot afford justice. And to the extent that even the criminals, uh, if we talk about the Kasab, even he was provided the legal aid by the court when no one was coming forward to stand on his behalf as an advocate. So to the extent of supporting a criminal, the Supreme Court had gone too far to provide the legal aid. So there are various cases on the legal aid: Hussain Ara Khatun, Ahmed Haskot, Nandani Satpathy. These are the cases where the legal aid provision has been made by the Supreme Court. So if we see that the Supreme Court has taken a very very radical approach, very very humanistic approach as per the Article 142 of the Constitution, in order to provide human right safeguards to the persons who are either involved in the crime or whom have suffered because of the crime, that is to the victims also. So if we analyze the position of criminal law and human rights jurisprudence after the Maneka Gandhi case, we find that there are multi-dimensional approach to the criminal jurisprudence, and the judiciary has contributed a lot in safeguarding the human rights of not only the criminals but also the victims also, by way of ensuring the right to life and personal liberty as well as right to dignity. Last thing that I wanted to discuss within few minutes is that is what are the challenges today before the administration of criminal justice. And you all know and are aware of the fact that now the people have started taking law in their own hands. There is not much respect left for the administration of criminal justice because of the insensitive attitude of the authorities, police personnel, or because of the delay which happened at the level of the judiciary. So people are now taking law in their own hands. You must have witnessed the case of Hathras, Hyderabad case, where the people themselves killed the culprit in order to provide justice to the victim. And this Me Too movement also started by the women because nobody was listening to them or to their grievances. So the criminal justice jurisprudence is being challenged today by the apathetic attitude of its people or the person living in the legal system, because people are not respecting the law just because they are not believing in the system, because they are not getting justice in time, and rather people are taking to social media in order to share their stories of human right violation. So the question is why the people are doing so, why they are approaching to social media, and why not they are approaching to the police or the judiciary in case the police is not writing their reports. So why the victim are losing trust in the administration of criminal justice. So it is all for us to ponder, not only as a student of law, as a teacher of criminal law, as a student of criminal law. we all need to ponder about it, to think about it, because sometimes what happens, the laws are poorly drafted, sometimes the laws are poorly implemented, and they do not provide full support to the victim. And sometimes the authorities are very, very insensitive, not only the police but judiciary also, because recently we had the cases from the High Court and the Supreme Court, very insensitive judgments were given, like the rapist should marry the victim, or the victim was given the proposal to marry the rapist, or uh, the woman who has been raped may tie a rakhi to the person who has committed the sexual assault, or the women are forced to wear the matrimonial signs on their body. So that kinds of judgments, insensitive judgments, have also been there, which have brought a kind of apathy on part of the victim, and they have lost faith in the, not only in the legal system but in the judicial system also. So for that, we need to have a kind of overhauling of the system. We need to protect the victim, we need to protect the witnesses, because many a times witnesses do not come forward for giving the evidences because of the fear, because of the pressure that are exercised against them. So we need to have the victim and witness protection programs at place. We need to have the therapeutic counseling by the lawyers, it can reduce the burden on the criminal justice administration. And then a kind of integrated approach is to be required, a kind of systemic reform is required, where all can work together, not only the government organization, non-government organization, civil society, international bodies, all have to play a very, very constructive role. And then there comes the role of our universities and the colleges, through our legal aid clinic, through our universities and colleges legal aid clinics. We can also sensitize the members of the society that we need to know the law, we need to respect the law, and in case it's of its violation, it has to be dealt with a human right jurisprudence perspective. So lastly, to summarize the things, I can say that if the human right jurisprudence is to be brought in the administration of criminal justice, then it requires a very, very holistic and multi-sectoral approach to address the complex dimension of the problems which are there in criminal law involving human right violation. Because we need to secure the rights and liberty of the individual, we need to secure the life of dignity to the victims as per the constitutional provisions. Because what happens when we are securing the victim, we are not securing that victim only, but also the persons who are related to him or her and to the neighborhood society. So essentially a human right perspective is very, very much required so far as administration of criminal justice is concerned. So with these words, I rest my presentation. So thank you all. Thank you so much for your patient hearing. Thank you, Manasvi.
Ma'am, thank you so much for bringing out such a holistic analysis of not only criminal justice administration, but also how people today are trying to take law in their own hands, or how when judiciary is trying to play a proactive role, maybe there are certain demerits within the judgment itself, not taking into account the socio-psychological analysis of the mindset of the victim while pronouncing such judgments. So, ma'am, thank you for very beautifully pointing that out. Ma'am, with your